Welcome to The Explainer. Today, we're going to talk about something that feels like a total nightmare, getting hit with a debt collection lawsuit. It can feel hopeless, right? But what if I told you there's a secret weapon you can use to fight back?
Okay, let's really get into it. Just imagine, there's an unexpected knock at your door. It's a process server, and suddenly some company you've never even heard of is threatening your entire financial world. It's a terrifying moment.
But here's the thing. What if you could flip the whole situation on its head? What if the key to making them back down is actually hidden inside the very contract they're using against you? Yeah, turning their own weapon right back at them.
All right, so to really get how this works, let's walk through a real-world example. We'll use the story of a consumer. We'll just call him John. His experience is basically the perfect playbook for how this whole thing goes down.
So John's story starts like so many of these do. He gets sued over an old credit card debt by some company he's never heard of. Turns out they're what's known as a junk debt buyer, and their whole business model is built around suing people just like him.
So what is a junk debt buyer? Well, these are companies that go to the original creditors, the big banks, the credit card companies, and they buy up massive portfolios of old, charged-off debt.
And they get these debts for an absolute steal. We're talking literally pennies on the dollar. Then, their whole game plan is to sue you for the full amount. They're banking on you being too intimidated or maybe just not showing up to court so they can get an easy win.
Right. So the key here is that their entire strategy relies on you not knowing your rights. They thrive on that fear factor, assuming you'll be too overwhelmed to do anything. But, and this is the good part, there's a powerful tool, one that's usually hiding in plain sight.
And here's the incredible irony. It's a weapon the credit card companies created themselves. You see, back in the late 90s, a bunch of the big players, think American Express, Chase, pushed to add these arbitration clauses to all their contracts. Their goal? To protect themselves from huge, expensive class action lawsuits.
And this is where their brilliant plan can backfire on the debt buyers who come later. See, a court lawsuit is what you probably picture. Public, super formal, lots of rules. Private arbitration, on the other hand, that's a totally different ballgame. It's behind closed doors, it's less formal, and it plays by its own set of rules.
Okay, so let's get practical. How do you actually take this obscure little clause buried in an old contract and use it to completely turn the tables on a debt collector?
It really comes down to a couple of key legal moves. First, when you respond to the lawsuit, you file what's called an answer, and in it you state that the original agreement requires arbitration. Then, you follow that up with a motion to compel arbitration. That's the official request asking the judge to move the whole thing out of the courtroom.
Now, the reason this even works is because of a legal idea called successor liability. Think of it like this. When the debt buyer bought your debt, they bought the whole contract, not just the parts they liked. They inherited all the rules and obligations, and that includes the arbitration clause. They can't just cherry pick.
So this is the big question, right? Why is this one move, forcing arbitration, so unbelievably powerful? Why does it make these guys who seem so relentless suddenly just drop the case and walk away?
Well, it all comes down to one thing: money. Plain and simple. Their whole business model is built on collecting debts as cheaply as possible, in huge volumes. Arbitration completely destroys that model.
Okay, check this out. A debt collector might sue you for, say, $2,000. But to even start the arbitration process, they could be on the hook for thousands in filing fees, not to mention paying the arbitrator by the hour. All of a sudden, they're looking at spending maybe $9,000 just for the chance to collect $2,000. The math just doesn't work for them.
And it's not just about the cost either. There are other big perks for you. For one, arbitration decisions are pretty much final, with very limited appeals. So if you win, it's really over. Plus, the whole thing is private, unlike a public court case.
So the big takeaway here isn't just some interesting legal theory. It's a real actionable playbook. So if that knock ever does come to your door, you'll know exactly what to look for and what to do.
Okay, let's recap the essentials. First, dig up your original credit card or loan agreements and look for that arbitration clause. And hey, if you can't find them, the Consumer Financial Protection Bureau's website actually has a lot of standard ones. Second, if you get sued, you have to act fast. File your answer and that motion to compel arbitration. That's the move that puts the ball and all the costs right back in their court.
And really, that's the ultimate lesson here, isn't it? The fine print we all tend to ignore can have some serious power hidden inside.
Knowing your rights, knowing what's actually in your agreements, it's not just about defense. It can be your best offense. It makes you think, though, the next time you sign something, what other secret weapons might be hiding in there?